wanted him back in your life, and Mr. Lewis dropped him off. I won't get into all the circumstances surrounding that, but I think it was May 26th of 2020 when he came back to you. Here's what you said shortly thereafter on June 13th. And this is where I know there's a redeeming quality in you. There was a yearning to be a parent and helping. Here's the quote. It's far different from some of the other quotes I've heard, but I'll get to those. I want to get this little boy help. My heart hurts for him. He just needs help. That's a mother who wants to help, not hate her little boy. And then we fast forward to September 2021. I'm not going to review all of these statements. You and the members of our community have seen them up on the screen. September 16th of 2021. Piece of shit kid. I won't use the words that precede that. Rotten kid. You indicated in terms of his life that you were the boss. And you went, it's my way now. I'll hang this kid. I hate him. September 21st of 2021, and I have to admit, this is a statement that says it all. We can talk about what happened in the bathroom, and we can have a factual dispute about it, but it really comes down to this. Just whooped the effing maggot's ass. I look at this is not a maggot. It's a beautiful little boy. Your words shine the light on your intentions. October 25th, today, we went from I hate him, I just whipped the maggot's ass, to I love you, Elijah. All of that has a profound impact on my view of you as an individual. Your words that I've seen are damning in this case. They are cords of terror that rain down on this little boy. They are cords of terror that showed your knowledge, your awareness of the torture you were inflicting upon this little boy. You admit today, and you admitted on September 26th, in very clear words, that you knowingly caused the death of Elijah. And again, I will not get tangled up in the minutiae of what happened, whether it be in the bathroom or other places. The evidence is way beyond a reasonable doubt. It's beyond overwhelming that your hatred imploded into neglect, beatings, starvation, facial and scalp injuries, blunt force trauma, pressure ulcers, hypothermia, confinement and isolation, leading to malnourishment and other acute conditions. Acute fentanyl intoxication caused this little boy's death. All those factors combined, and those are coming from the experts, the autopsy. It's an abhorrent, heinous, prolonged terror and torture of a 5-year-old boy, inspired by pure hate. Your words give me a very close view, an inside and up-close personal view of your knowingly intent in this case. You knew exactly what you were doing to Elijah. You were killing him hour by hour, day by day, month by month. That's the crime I'm looking at. Now my obligation is to weigh the constitutional objectives of punishment, deterrence, and rehabilitation in the light of who you, Ms. Dauphinais, are as an individual. There's been talk and there's been pleadings and argument about the comparables in this case. And I've looked through all of them. Obviously, in terms of the State versus Marin case, I lived it for years, tried the case, and sentenced Ms. Marin to 45 years to life. The comparables, while they give me some sense of how other judges have sentenced people in similar circumstances, but not the exact circumstances, because Attorney Faulkner, Attorney Durand, and Attorney Hageman, Attorney Jerusalem, you know that sentencing is an individual journey. and I take that very seriously. I have to know the individual who is before me, the crime he or she has committed, and then weigh those constitutional objectives against it. And that's what I'm doing in this case. There is no doubt in my mind also on the other side of things from a mitigation standpoint, based on what I've read about you and heard about you today, that you suffered adult traumatic childhood experiences that impacted your life, both as an individual and as a parent. Adverse childhood experiences. I've read about it in many cases, been trained on it, understand the studies. There is no doubt that you were surviving through that. There's no doubt that it had an impact on your parenting of this little boy. There's no doubt that there was modeling for you that was horrific. There's no doubt that you suffered pain, trauma, abuse in your childhood. And for the most part, especially considering the studies and the research and the publications on that, I consider that a mitigation factor that I've accounted for in my sentence. I've also accounted for what I view as your remorse, your sorrow, and your acceptance of responsibility in this case by entering your plea of guilty. Those, in my view, are all mitigation factors. It is interesting, though, in terms of your adult childhood experiences, from everything I've heard, everything I read, that modeling did not bleed into your life in terms of your daughter since her birth in 2019. So we had very different pictures. We had Elijah in the basement, and then we had you parenting actively your daughter. Not exposed to what Elijah was being exposed to. So it's profoundly interesting, and I gave it a lot of thought of the dichotomy between these two children and how that was impacted by your childhood experiences. So I'm going to view that, though, primarily as mitigation in this particular case for you, and based on what you told me about it personally today and through Attorney Jersham. The aggravating factors I've talked about already. The primary aggravating factors in this case are your intent and your actions that just speak volumes about the terror and the trauma and the torture that this little boy was experiencing at your hands. And I am not in any way absolving Mr. Staff of his role in that. He had hands on this child. He was there a lot of the time. His guilt has been borne and he is serving his sentence. But he's right there with you. He's a part, ultimately, and he's admitted so. The level of your consciousness of guilt is also proven way beyond a reasonable doubt just in the burial circumstances, both your words and your actions. And I'm not going to go through it. You lived it. We've heard a lot about it from the state, justifiably. That is a journey through your words and through your actions that was, to quote Attorney Faulkner in his view of these circumstances, terrible. I think it's beyond terrible, and I agree with him that it's a complete nightmare. The main brunt of this nightmare, and a person who lived a nightmare beyond all nightmares for months, was little Elijah, isolated, in a shower, with complaints over Facebook, especially in the last week of his life, that he won't stand up. This 19-pound tortured little guy couldn't stand up. Just horrific. A brutal reign of torture for months, a slow, prolonged, and painful death of an innocent and blameless 5-year-old boy. A trail of words and actions that scream of the evil that was put upon this isolated, little, defenseless tell you that as I view this case, Ms. Dauphinais, I view it as a case where punishment is at the highest level. Both proposals ignore them. Both proposals support that. They evidence it. Your proposal for 35 years to life and the state's proposal of 55 years to life. Incapacitation has to be the primary goal of this sentence. We have to remove you from society and show society from a judicial standpoint that justice will be done and the community, especially the children of the community, will be protected. Deterrence, both individual and general, is very clear in this case. I have to send you and the community a very clear message that we will not tolerate a rain upon a little boy that causes his death through hatred, through starvation, through hypothermia, through neglect at levels that are not often seen, if ever. So that message will be sent. In terms of rehabilitation, the case law is very clear. The Constitution is very clear that really the ultimate goal of any sentence is rehabilitation, but it's a minimal goal in this case. It's a goal that you can still accomplish while you're in prison. It's a goal that you can live your life there in a way that is an example to others, disciplinary-free, engaging in programs, furthering your education for the time that you are there. So you can engage in rehabilitation and reform, and I expect and hope that you will. That's everything that has been weighed into the sentences. It's a case, as I said before, that will stay with many in this courtroom, and it's a case that deserves significant, severe, and prolonged incarceration. With that all being said, if you would stand, I'm going to sentence you as follows. These three sentences are all in 226-2021 CR 944. To charge ID number 9196813-1C. Upon your plea of guilty to the crime of second-degree murder, knowingly, you are sentenced as follows. You are sentenced to the New Hampshire State Prison for not more than life nor less than 50 years. There is added to the minimum sentence a disciplinary period equal to 150 days for each year of the minimum term of your sentence to be prorated for any part of the year. You are entitled to pretrial confinement credit of 1,103 days. This sentence is to be served as follows. Stand committed, commencing October 25th, 2024. The sentence is consecutive to 226-2021 CR 944-196901C if that sentence is ever imposed. Other conditions of this sentence are, if required by statute or Department of Corrections policies and procedures, you shall provide a sample for DNA analysis. In terms of restitution, you shall pay restitution capped at $40,000. I trust that that restitution will be paid through the correctional facility or Department of Corrections as directed by the probation and parole officer. A 17% administrative fee is assessed for collection of restitution, so I will check that box off. Counsel, is there a need for a hearing on restitution? If so, I'll check the next box off regarding the request to address that.
Excuse me. Your Honor, at this time, we have no claim for restitution to be made, so I don't believe we need a hearing.
Okay.
We'll notify defense counsel if something changes.
Very good. Thank you. So I want to check the other box. As it relates to your appointed counsel, based on your incarceration, I find that you have no ability to pay counsel fees and expenses. You are to participate meaningfully in and complete any counseling, treatment, and educational programs as directed by the correctional authority or the probation and parole officer. In terms of the no contact provision, it's a stand committed sentence, so I will vacate that condition under state versus toll. That will be taken care of administratively at the prison. Law enforcement agencies may destroy the evidence or return evidence to its rightful owner. The defendant and the state have waived sentence review in writing and on the record at the hearing on September 26, of good behavior and comply with all terms of this sentence. Good behavior means that you not commit any federal, state, or local crime. And finally, first of all, you waive your right to seek earned time credit under RSA 651A22A. Secondly, you may not profit in any manner from these offenses, including the murder, life of Elijah Lewis, or flight from the investigation. Specifically, you shall not accept any payment, enter into any contract, or sell any rights regarding any book, film, television show, radio show, website, podcast, or any other writing, recording, broadcast, or internet posting relating to the offenses, the murder, or Elijah Lewis. Do you fully understand that sentence?
Yes, Your Honor.
Then we'll proceed to the two sentences for witness tampering. Those sentences are identical and concurrent with each other and consecutive to the sentence I just read to you if they are ever imposed. So I'll read these to you one time. Again, upon your plea of guilty to witness tampering in charge ID numbers 1969001C and 1969003C, findings of guilty are entered and you are sentenced as follows on each of these convictions. You are sentenced to the New Hampshire State Prison for not more than 7 years, nor less than 3.5 years. There is added to the minimum sentence a disciplinary period equal to 150 days for each year of the minimum term of your sentence to be prorated for any part of the year. The sentence is to be served as follows. Stand committed, commencing October 25th of 2024. The sentences are consecutive to charge ID number 1968131C. That's the second-degree murder sentence. They are concurrent with each other. Again, if required by statute or Department of Corrections policies and procedures, you shall provide a sample for DNA analysis. And again, as it relates to your appointed counsel fees, the court finds you have no ability to pay counsel fees and expenses, and you are to participate meaningfully in and complete any counseling, treatment, and educational programs as directed by the correctional authority or the probation and parole officer. Law enforcement agencies may destroy the evidence or return evidence to its rightful owner. You and the state have waived sentence review in writing and on the record on September 26th of this year. You're ordered to be of good behavior and comply with all terms of this sentence. You waive your right to seek earned time credit, and as I read to you before, there's a condition that you may not profit in any way from these particular offenses, the murder or Elijah Lewis. I won't read those words to you again. You've already heard them directly, but they apply to both the witness tampering sentences as well. Do you understand those two sentences, Ms. Dauphinais?
Yes, Your Honor.
Anything further from the state? Attorney Duran?